So a lot of people put the cart before the horse in a civil dispute. Now, what I mean by that is not actually properly at the very outset estimating or particularizing, is the fancy legal term, their losses. What they do is they become very worked up and upset, aggrieved, angry about what somebody else has done to them, and they see red and they're lost in the mist of emotion, and they just simply can't see the situation clearly and apply themselves surgically to what ultimately is a financial dispute. Now, the county courts, civil litigation, the civil justice system, as you know, and I'm tired of saying this to people, is an arena for settling disputes between individuals on the basis of compensation, financial compensation, as best as possible, quantifying the losses to a party and making an award accordingly. Obviously there are exceptions, but the vast majority boil down to money. Now, I had a legal surgery with a good client recently whose head's really switched on, but even he, in respect of a financial dispute, was sort of focusing on the wrong thing. I'll come on to explain why that's dangerous, okay? It was a mortgage taken out by a bank many years ago, and it now come to the end of the mortgage term. Now, back in the day, when he was in some difficulties and had an overdraft and borrowings with his bank, he tried to take out another mortgage with another lender, and his bank said, "You've got to take it out with us, and if you don't, we're going to call in the overdraft and the loan." Yeah, even though actually he was calling the overdraft, even though actually he wasn't falling behind on that overdraft. Yeah, quite dodgy move by the bank, isn't it? Really sort of stitched him up. So they forced him to buy their own product and to wrap up all the borrowings into a long-term mortgage where they can hide things like payment protection insurance and you know, high interest rates compounded over time. The eighth wonder of the world is compound interest, so the client doesn't really realise how bad a deal he's getting. So you know, he was aggrieved about that, and now he wants to sort it out and resolve this issue. Now, it's quite clear to me, was quite clear to me, that the bank had probably been dodgy back in the day, around about 2008. Well, you know, perhaps since the world was first created. Banks, yeah, well, they weren't on performance targets at the time that the world was created, but certainly in the past, you know, 30, 40 years in the UK, everything has become about sales, isn't it? So the bank manager has flipped into a salesman, perhaps without even realising it. And he's under performance targets. So he's got to flog his high interest rates. He's got to flog his own products, his own bank products, and any add-ons that are the true profit centre of the banks, like payment protection insurance. Yeah. So that was all pretty clear to me. Now, the whole consultation could have got bogged down in a conversation about whether the evidence was there to prove this in a court of law. But really, the critical question, before we start getting on our high horses, is what was his loss? Pounds, shillings and pence. What was his loss if he had not gone, or rather not been shoehorned, or I mean, it was also really coerced into taking out the bank's own loan or mortgage. Yeah, and he hadn't considered that, and he didn't have any maths on that. So, you know, the conversation turned to drilling into the maths. Yeah, I've checked with the client; he's okay me talking about this case. And you know, he's a true blue, and he probably sees the benefit to himself and the benefit to the world in producing a vlog like this. I'd love to go into greater detail, but obviously I can't. Anyway, so what he needed to do was, before he started spending money on lawyers, even, buy the book though, that doesn't cost you much. People are such cheapskates, they won't buy the book. And they might have a £50,000 claim. It's packed with so much good knowledge and information of like 25 years litigation experience boiled down into a beautifully bound hardback copy if you want to go large. And it's got all the sort of tables and explains particularizing losses and so on and so forth. So anyway, plug over. So really what you need, and I mean, you don't have to be a lawyer to do it, but a lot of people end up instructing lawyers and spending thousands of pounds on turning the lawyer into not a secretary, an expert at working with Excel spreadsheets, is to do 2 columns. The mortgage or the loan he would have taken out with a third party lender. Let's say it was Cheltenham Gloucester, and let's say he's with, I don't know, Barclays Bank. You can see how the high street banks might have been trying to steal business from traditional building societies. And, you know, put in what he would have paid under that deal. If he didn't actually get, you know, a schedule of interest payments over 25 years from Cheltenham and Gloucester, then what was the average? What was the typical deal that was being offered? Let's say by 3 different main lenders. Do you see how you can get round the problem that you might not have a specific quote? And then, you know, work out what the total is, and then the second column put down Barclays, and work out what you actually paid, yeah, and what you would have paid over 25 years with Cheltenham and Gloucester, include obviously costs and any other issues, compared to what you actually paid with Barclays over 25 years. There's your claim value. So why is this so important? And to broaden out the message that I'm trying to convey to the good folk out there now is, let's just say that the calculation is 5,000. The difference is 5,000. Well, it's a small claim. Don't need a lawyer. Don't need to go to a lawyer. You've already done the spade work. Hopefully, incidentally, you've also, you know, got hold of all the bank statements. Spade work. You don't need a lawyer. You know, then you kind of got a better idea of the battleground, the sort of like the route to battle. What it's going to involve. Well, it's not going to involve too much, is it? Let's say it's a fast track claim, yeah, in the sort of £10,000 to £25,000 range. Be careful, there's now an intermediate track, but just to keep it simple to illustrate the point. In a simple fast track claim, you never get your costs back, your full costs back, even if you win. So you might spend, especially now that they've created this fixed costs regime. So you might instruct a lawyer. They might not be brilliant. They might have 50 other cases like yours, and they might just be turning the handle. And your case may need, particularly if it's financial and selling, may need more legwork, and you know, legal. You might need someone with a real legal brain. You know, that's starting to look like a false economy to instruct lawyers, even though it comes into a range where you'll get your legal fees back if you win. Yeah, but how much? And maybe if you're losing 40% of your legal fees and you've paid $25,000 to take it to trial, and actually the value of the claim is only $10,000 or $12,000, you know, what's that? Do the maths. 25,000, 10%. You know, that's that's 10 grand in legal fees that you might have lost. Let's say, you know, you rarely get your full legal fees, you see, in litigation. So yeah, and then obviously if it's a higher value in the multi-track, then, you know, you might take a view. If it was in the fast track, you might say, well, I'm going to use a service like Court Wingman, or I'm going to buy the book and do it myself. I've got a nephew who's a law student or whatever, or I'm a paralegal. You know, or I've run a bunch of cases through the courts before. Warning, I'm very, very, suspicious of people who've got like half a dozen cases out running in the civil courts. I've only ever been to the court once in my own right. And before I was a lawyer, small claim. So, do you see how important that initial task of estimating the losses is? And, you know, it's kind of being emotionally cool, isn't it? And that's so difficult. I mean, I think a lot of the people who do talk to us through the Court Wingman service, they know that their judgment is probably clouded because they're so close to the dispute. And they're coming to us as much for a sort of a sounding board, a neutral, clear-headed, obviously trained and experienced, but, you know, a big part of it is we've not got skin in the game. We are neutral, detached. So yeah, and obviously if it is a small claim of low value, then buy the book, watch some videos, and, you know, hopefully you'll be home and dry. And I get a lot of people, you know, to flip it round on the plus side, if you are watching this video, if you have bought the book, you are, you know, a step ahead of your opponent, quite frankly, because they'll be wedded to their case and you know, and that will get them into hot water if they're not careful. I'll tell you, it so often happens that people just like, they're absolutely stunned when a judge finds against them. But if they were to step back, they could probably, if they're honest with themselves, see why that judgment was found against them, yeah? It's not just financial mis-selling, although that's, you know, in terms of actually estimating losses, that's obviously quite critical. And as I say, so much money can be saved by getting all the documents together yourself and doing the maths yourself on an XLS spreadsheet. You know, take a personal injury case. You might think, you know, damn it, that whatever it was, hospital, if it's clinical negligence, cocked up the operation and whatever it might be. Well, you know, you need to actually particularize the losses in terms of the time that you spent out of employment, for example. Let's say you broke your wrist. Well, okay. But actually, you know, the fee for a broken wrist might not be very much. And these days in the personal injury sector, the threshold for small claims is going up. So you've got to have a more serious injury to get it onto a cost-bearing track where you can instruct a lawyer and get your fees paid back if they win, get traditionally a no-win, no-fee law in the personal injury sector. Yeah, but what about, and when we do get personal injury cases, it's often because of some element of complexity, which the big PI factory firms aren't set up to handle. What about if you're a violinist? And what about if you were off for 3 years? Or 18 months, and you had a big few concerts coming up that have earned you 50 grand's worth of income, because that's the way it works in the music business. Feast or famine, you know. Then, so you need to calculate early on, not get on your high horse about the other person did it, and I can prove that their negligence broke my wrist. But what's the likely quantum of the claim going to be? Because if there, and can you prove that you were genuinely unable to play the violin for 18 months? In cohabitation property disputes, where it's so commonplace in the UK, and the government won't change the law and make it the same as marriage. So you've got cohabiting couples, and both names go on the deeds because they were in love. And there's kind of this understanding that we'll pay the mortgage and I'll look after the kids, or vice versa these days in the wokey world, I guess. So you've got there a situation of calculating whether or not the financial contributions by both parties was significantly different, such that you can probably begin to overturn the presumption that the property is owned 50-50 because you're both in the title deeds. You know, a few years later the relationship breaks down and one party's paid all the mortgage and the other party's done nothing, but still wants half of the property. Yeah, that it becomes easier for us, the lawyers, to overturn the presumption where, generally speaking, there are other factors at play. Look at the other cohabitation videos for legal tips on that area. You know, but generally speaking, if one party's only contributed 10%, the other's 90%, you probably find an argument, if you're a half decent lawyer, that the real intention was that the property should be divided according to the respective financial contributions, the percentages. Yeah. Or that the intention changed later on when the relationship started to break down, or earlier, or whatever, or when one party couldn't afford and they had afford to pay the mortgage, they had an arrangement that they would then split it in terms of contributions, whatever. But you need to have calculated those contributions. You need to have got a hold of your mortgage statements. You know, you need to put all the figures into a spreadsheet. I know it's a headache, but you know, why pay a lawyer £200 or £300 an hour to do it when you could do it yourself? And really be surgical and mathematical. I only got a C in my maths O level. It was a really poor subject for me. I've had to learn the hard way. I've now become a master at Excel. You can do it, yeah. And this comes on to another point as well, which is when you are prepping up and you know you're at this sort of war council stage, whether you're going to go to war. You know, be getting, and if there's one soapbox that I'm fond of more than any other, be getting your documentation in apple pie order. Those are the clients who win, whether they do it themselves or instruct a lawyer. That means, yes, getting all your bank statements together, getting the printouts from the estate agents when the property was rented, going to the bank and getting your statements from them, and trying to get it in an Excel format if you can, so you don't have to number crunch your way through your bank statements. Get all that documentation together, or if you're the violinist, you're going to need to get the lawyer. It could be a high value case, is going to want to see the contract with the concert hall, saying, yep, on the 5th of January, we are offering you a paycheck of $5,000 to appear in our concert. I've had a case like that was transferred from a factory firm, and she was a country and western singer, and it was a minor-ish injury, but it had caused a lot of financial losses. So hopefully there endeth the lesson, and that does make sense. Takeaway: try and get into an emotionally cool place. Yeah, physically as well. Shut yourself off from the world if you're going to do this exercise. Use other people, whether it's a legal service or just someone who's a cool-headed businessman, and go through it with them and get them to help you. But get yourself mentally prepped up that it's a commercial endeavour, and when you're having that little war council within yourself, you need to be working out what your likely losses are going to be, your likely win is going to be, because so many other things follow from that. And the second takeaway is, actually do the exercise and do particularize the losses, and get the documentation together in apple pie order in order to make that job so much more easier. Good. Don't forget, in terms of putting your documentation together, on the website there is a vlog that shows you how to do that. It just will, whether you use lawyers or not, it is the golden rule. If you fail to prepare, you are preparing for failure. So let's leave this vlog on a slightly gloomy note. Thanks for tuning in.